Welcome to this explainer. Look, if you're managing co-parenting finances here in DC, you already know it's a massive balancing act. But today, we're zooming in on the precise intersection of federal tax law and local family court. It's a place where a huge financial blind spot is costing families real money every single year, simply because they don't realize what they're actually allowed to share.
All right, let's dive right in. Here's the absolute biggest, most underutilized surprise for divorced parents. Both of you can use your own health savings accounts to pay for the exact same child's medical expenses. There's this huge misconception out there. Most people assume that if your ex claims your kid is a dependent on their taxes, you're just locked out of using your tax-advantaged HSA funds for their braces or prescriptions. But as we're going to see, the IRS has actually carved out a highly specific and highly valuable exception.
To navigate all this, we're going to hit 5 key areas: the double HSA advantage, IRS rules, DC court obligations, the 30-day deadline trap, and finally, why compliance lives and dies in your documentation. Let's get to it.
First up, Section 1, the double HSA advantage, straight from IRS Publication 969.
So here's the foundational rule. You actually do not need to be the parent claiming the child on your tax return to use your HSA funds tax-free for their medical care. As long as that child is in the custody of one or both of you for more than half the year, the IRS effectively says, hey, they're a dependent for both of you when it comes to HSAs. It's a total game changer. You don't have to be the primary custodial parent. If your divorce decree says you pay 40% of the uninsured medical bills, you can use pre-tax dollars from your own HSA for that 40%, while your ex uses theirs for the other 60%.
Moving right along to Section 2, IRS rules and the sheer opportunity we're looking at with the 2026 contribution limits. These newly increased 2026 limits really amplify the strategy. The IRS adjusted these figures for inflation, and it creates a powerful wealth-building tool if you know how to leverage it. If you're enrolled in a self-only high-deductible health plan for 2026, your individual maximum contribution limit is $4,400. But quick heads up here, it's your health insurance plan that dictates your limit, not your family law status. Even if you're paying for your kids' bills, if you only have a self-only plan, you are strictly capped at that $4,400.
Now, if you carry family coverage, that limit takes a massive jump to $8,750. Think about the pool of tax-free money that creates when both parents are contributing. If you've got family coverage and your ex has self-only, between the two of you, you're looking at over $13,000 of tax-advantaged space. Throw in a $1,000 catch-up contribution if either of you is 55 or older, and we're talking about thousands in tax savings every single year. You are effectively discounting those medical bills by your marginal tax rate.
Which brings us to Section 3, DC Courts and your legal obligation under DC Code, Section 16916.01. So, the IRS gives you this great tax carrot, right? Well, the DC Superior Court brings the legal stick. Under DC Code, parents have to share uninsured medical expenses that go over $250 proportionally, based on their adjusted gross income. It completely dictates who pays what on a theoretical $2,000 bill. We're not just casually splitting it down the middle 50-50. Because parent A makes $80,000 and parent B makes $50,000, the court calculates their combined income and assigns a rigid percentage. Parent A is legally on the hook for exactly 62%, which means they are paying $1,240 of that bill. And here's a crucial detail. DC courts use an incredibly broad definition of income to figure out those percentages. Almost all your revenue streams are getting factored into your obligation. If you thought it was just your base salary, absolutely not. They're looking at overtime, capital gains, rental income after operating costs, and yep, even your lottery winnings. So, maybe keep those scratch-offs a secret. Plus, if your income shifts significantly, usually by 15% or more, you literally have to petition the court to modify the order. You can't just casually agree over text to pay less.
All right, Section 4. Let's talk about the 30-day deadline trap, because this is a brutally strict legal timeline.
This is exactly where financially savvy co-parents trip up. They treat medical reimbursement like some casual favor. Don't do that. The exact second one parent receives written proof of a medical expense and payment, a rigid 30-day legal clock starts ticking. It's not a polite request timeline. If your ex takes your kid to the pediatrician, pays the copay, and gives you the receipt, DC law demands you reimburse your proportional share in exactly 30 days.
And missing that 30-day deadline, it instantly transforms good intentions into literal contempt of court. A judge can garnish up to 60% of your wages or even suspend your licenses. That is a staggering escalation. If you blow past that window, your ex can file a motion for civil contempt. The Consumer Credit Protection Act allows up to 60% of your disposable income to be withheld to cover child support arrears, which absolutely includes unpaid medical support. Oh, and they can intercept your tax refunds or suspend your driver's license. The stakes could not be higher.
This brings us to our final section, Section 5. Compliance lives in documentation. This is your ultimate defense.
Look, in family court, your financial safety relies 100% on a bulletproof paper trail. You have to satisfy two very different, very demanding bureaucratic beasts, the IRS and DC Superior Court judges. Casual text messages? Totally meaningless. A text saying, hey, the dentist was $500, you owe me half, will not hold up. You absolutely must maintain and present these 5 things. The itemized provider bill, the explanation of benefits, or EOB, to prove what was actually uninsured, the math showing your exact proportional share, your HSA payment receipts, and crucially, a date-stamped written notice to prove exactly when that 30-day clock started.
So, as you map out your post-divorce healthcare strategy, you've really got to ask yourself, will a single missing receipt be the oversight that completely tanks your case and drains your cash? You know the double HSA strategy now, but you also know the severe DC court penalties waiting if your paperwork is sloppy. Don't let a lack of organization turn a brilliant tax break into a legal nightmare. Keep those records pristine. So, I'll leave you with this. Is your current co-parenting system actually protecting your wealth, or is it just a ticking 30-day clock